Hi, everyone. Thank you for joining us today in the discussion on strategies for taking your companies private. My name is Bennett Wong. I'm a partner at Dentons based in the Calgary office. I'm also the national lead of our securities and corporate finance practice. This year, we've been seeing an uptake in going private transactions in both Canada and the US across multiple sectors and market caps by financial, strategic, and opportunistic buyers. Uncertainty in the equity capital market space in the past year has attributed to more companies being taken private than listing through traditional IPOs. This trend is also partly driven by companies refocusing on their long-term strategies. Today, we're going to discuss the benefits going private, some structural alternatives, the role of board and management and process, some cautionary tales, and key considerations for success. I'm thrilled to have four distinguished speakers with us today to share the insights on this topic. Jason Spasaro, Vice President, Business Development, Computershare, focusing on public and private M&A. Chester Wudachik, Project Manager, Corporate Actions at Computershare. Riley Dearden, Corporate and M&A Partner at Dentons. Andreas Kloppenborg, Corporate and M&A Partner at Dentons. Just a couple of quick housekeeping items before we get started. For those of you who are not familiar with Dentons, we have a very strong team with over 120 lawyers across the country specializing in corporate finance and capital markets work. We welcome the opportunity to connect with you and to provide any legal support you may need in these areas. Be sure to check out our Going Private in Canada Resource Center, which is available on our website and includes a comprehensive guide detailing different options to go private, the transaction process, and regulatory considerations. For accreditation purposes, this session is eligible for 60 substantive minutes with the law societies of BC and Ontario. As you can see, only the panelists will be able to speak and everyone else being put on mute. If you have any questions, please use the chat function on the bottom of the screen and type in your question. We will do our best to address them all, but the plan is to wrap this up by 2 p.m. Eastern so it doesn't interfere with your other commitments. To the extent we cannot get to your question today, we encourage you to follow up with us after. Finally, this session is being recorded and will be made available in the post-event email and also on our website and social media. Now, without further ado, I will pass the mic over to the speakers to give a brief intro of their expertise and experience with facilitating going private transactions. Riley, why don't we start with you?
Yeah, thanks, Bennett. Good morning or good afternoon, everyone, depending where you are. As Bennett mentioned, I'm a partner in the Calgary office. My practice focuses primarily on mergers and acquisitions and capital markets transactions. And over the years, I've participated in a number of go private transactions on both the buyer and the target side. Most recently acting for a TSX listed ag tech business as it was taken private through a management buyout.
Hey everyone, my name is Andreas Kloppenborg. I'm a partner in the Toronto office, practicing primarily securities and M&A, both public and private. While my practice is fairly broad, I'm currently working on several go privates at various stages of the transaction. And over my time at Dentons, my experience relating to go private transactions primarily focused on the tech and energy spaces.
Hi everyone, I'm Jason Spasaro. I'm a VP of Business Development for Corporate Actions at Computershare. As Bennett mentioned, I specialize in both public and private M&A. Although I'm based in Toronto, my sales role does cover all of Canada. In addition to depository services for going private transactions, my other key areas of focus include cross-border mergers and schemes, private paying agency with digital solutions, and asset reunification programs. I do have to say, if this was a one-on-one conversation, right about now is when I would get the natural follow-up question about my role at Computershare, and the most common one being, excuse me, sir, can you just repeat what you just said, but in such a way so I can actually understand what you do? And that's my wife speaking.
That's a good one, Jason. Hi, my name's Chester Wudachik. I'm here to talk to you today about the transfer agent and depository role of going private transactions. I've been with Computershare for the past 16 years, doing various roles. For the past 5 years, I've been a corporate actions project manager, handling hundreds of transactions including plan of arrangements, consolidation, rights offerings, substantial issuer bids, and a variety of other corporate action events. Usually, in fact, always when I talk about transfer agency and the role of Computershare with my family or friends, they lose interest in approximately 3 seconds. So it's nice to have a captive audience today.
All right, thanks, guys. Let's dive into it. Andreas, what do you think are the particular factors driving more going private transactions in recent years?
Thanks, Bennett. Great question. With the softening of the capital markets over the past 18 months or so, we've seen an increase in take private transactions, especially in the tech market. Last year, the tech sector obviously experienced a pronounced sell-off, which led to a number of private equity-backed buyouts, where the thesis is that private equity can take a longer investment view until market conditions recalibrate and exit opportunities develop. Thoma Bravo's acquisition of Magnet Forensics, which we worked on earlier this year, is a great example of that dynamic. Other key factors driving privatizations, which are always present but perhaps more obvious during these stages of less capital market activity, are simply private companies can restructure and pivot more nimbly. Private companies can wait out the soft capital markets more effectively, provided that they have a strong balance sheet and access to private capital. And lastly, of course, is eliminating the ongoing public company costs and reporting obligations to improve the bottom line of the business.
Okay. Thanks, Andrea, for setting up the stage here. Riley, what are the different structural alternatives to go private? Any particular considerations public companies should take into account when they're evaluating which approach to follow?
Yeah, thanks, Bennett. As I'm sure you can imagine, there are a number of different ways you can structure these types of transactions. I do say generally those wanting to implement a going private transaction will want to accomplish it in a single step, and they would typically use a shareholder meeting for an amalgamation squeeze out, a share consolidation, or a plan of arrangement. I do note, though, that both amalgamations and share consolidations can be implemented by way of a plan of arrangement, which is often the preferred structure for these types of transactions. So as part of a plan of arrangement, a judge will determine the fairness of the transaction, which provides some additional comfort to all of the parties involved. And although most going private transactions are conducted pursuant to a plan of arrangement, a number of significant transactions have also been accomplished by a takeover bid, with a second step transaction following as necessary. One of the benefits of a takeover bid is that it avoids certain negative tax consequences that are associated with going private transactions that you might find in a plan of arrangement or another structure. Now, as far as what public companies should consider when exploring a going private transaction, I would say first and foremost, the parties will need to make sure that they have the time and the commitment to engage in what can be a lengthy and involved process. Generally, the timing to close a going private transaction is a minimum of 60 to 90 days, and it could take longer in certain cases as well. Additionally, when a public company is determining which structuring approach will be best for them, I always say they have to have a very good understanding of their shareholder base, including how many shares are held by insiders or held by U.S. investors, and how widely those shares are traded on the market, as this can impact the structure we go with in the end. And finally, how the transaction is going to be funded and the requisite level of shareholder approval that will be required are key considerations that come up in the structuring phase.
Thanks, Riley. So from a deal execution perspective, Jason and Chester, at what point should transfer agents like Computershare be engaged in the conversation? How can companies be better prepared from the beginning of the process? And what about shareholder communication strategies?
Right. So I'll start off on the transfer agent side. So typically the transfer agent for the going private transaction would be contacted at the time the meeting needs to be set up. Typically there's a meeting that a special resolution needs to be approved on for a going private transaction. So if it's a standard meeting, which is not notice and access, then the transfer agent should be contacted 25 days prior to the record date. And then Computershare, the transfer agent, would typically mail 5 to 7 business days after the record date. And then the meeting date is typically to 30 to 60 days after the record date. And since this is a going private transaction, the transfer agent would be shortly terminated after the plan of arrangement is or the going private transaction has closed. If the meeting is notice and access, there's a slightly different timing there. So in that case, the record date must be set to no less than 40 days prior to the meeting date. And the mailing must be no less than 30 calendar days prior to the meeting date. Mailing documents will be the proxy package, which will include the notice, proxy, or voting instruction form, the VIF. And the proxy materials must be posted on CDAR and a non-CDAR site for a period of 1 year after the mailing date. Jason, on the depository?
Yeah, and similar to the meeting timeline, the depository function has its own critical timeline that issuers need to consider early on during the go private process. So first, timing for depository engagement. The issuer should consider engaging the depository agent around the time that the notice of special meeting is set up with the transfer agent. Early engagement will just allow the depository to proactively provide input on shareholder deposit and payment mechanics, which would be described in the circular. Timing for signing a depository agreement. Ideally, we say that the depository agreement should be finalized prior to the shareholder mailing, but at the very least, prior to the effective date. In terms of the effective date itself, is typically within days of the special meeting and shareholder approval of the resolution being passed. However, there is instances where, subject to court approvals, the effective date may be months following the shareholder approval. And when it comes to timing for payment of the consideration, the depository will issue and release payment within 3 business days following the latter of the effective date and funding by the issuer to the depository. Just a couple of related points I want to touch on regarding payment release. The first one being that the closing payment itself, the release will include payments to the depositories being CDS and DTC and registered holders who made a valid deposit prior to the effective time. So those registered holders who submit their deposit on or after the effective date, they would actually be allotted a payment in a subsequent payment release. And then lastly, insiders and affiliates not entitled to the consideration. I guess the best example here would be those are affiliates who are part of the buyer group who need to be carved out from the cap table payout. If these affiliates hold their shares with a broker, they actually have to ask their broker to withdraw their shares from CDS or DTC prior to the effective date. And the reason for this is that to ensure that CDS and DTC can reconcile funds, they need to receive the amount of funds that they're being paid out. They can't be over or underfunded. Chester?
Yeah, and so for shareholder communication strategies, there's a variety of instances where the shareholders receive information. First is press releases. So typically when the transaction is announced, there is a press release, and there may be a variety of press releases after that as the deal progresses. Then there's the meeting materials that get delivered to shareholders. So that's another form of communication, the information circular, a letter of transmittal, the proxy package. Approximately the same time the materials are mailed is when CDS and DTC post their bulletins. And so those bulletins go to the participants of CDS and DTC, the brokers, so they know if there's any elections or how to handle the corporate action event. Registered shareholders often do not submit letter of transmittals prior to the effective date. So therefore, if there's an extended period of time between the meeting date and the effective date, and it's possible to send a reminder mailing to shareholders, then that is something to be considered. Also, if the client has a relationship with shareholders, or if the shareholders work for the company, then the client or the issuer, they can remind the shareholders to submit their letter of transmittals to the depository in order to receive the payment as quickly as possible. And then once a transaction goes effective, delisting is shortly after the effective date, typically 1 or 2 days and after the effective date. And then CDS will be paid shortly after the delisting date, and so as a DTC. And then registered shareholders will also be paid depending if they submitted a letter of transmittal or not.
Okay. Thanks, guys. Let's switch gear and talk about formal valuation and fairness opinion for a minute here. Andreas, so what are some of the circumstances where a formal valuation or fairness opinion is needed? Any advantages to pick one over the other?
Sure thing. Multilateral Instrument 61101 imposes several procedural and other protections in certain going private transactions that are related party in nature, which may present specific issues and challenges for the acquiring and or target companies, including delays, costs, and additional scrutiny or approval requirements. MI 61101 identifies 4 types of transactions that are subject to its provisions, namely insider bids, which is effectively directors, officers, or significant shareholders buying the target company. Second would be issuer bids, which is the issuer itself purchasing its own shares, absent an exemption. The third would be business combinations, which is a transaction that confers a collateral benefit on a related party, together with a squeeze out. And fourth is a related party transaction, which is a prescribed transaction that is with a related party. The instrument itself generally provides the following procedural protections to the public shareholders whose shares are being acquired under the terms of the transaction. First, Bennett, to your question, the first one is formal valuation, and that needs to be performed by a qualified and independent valuator that contains the valuator's opinion as to the value or range of values representing the fair value of the securities or other property that's subject to the transaction. The second protection is minority approval of the proposed transaction by a majority of the votes cast amongst the public shareholders at the meeting called to consider the transaction. So that excludes, for the purpose, shares held by interested parties. The third protection is the requirement for a special committee of the board to be formed, composed of independent directors who do not have a conflict of interest. And the function of the special committee for this purpose is to supervise the preparation of a formal valuation in connection with the transaction and supervise, generally the negotiation of the transaction. And then lastly, the fourth protection that the instrument provides on minority interests is specific disclosure requirements in addition to those otherwise prescribed under applicable law, that being applicable corporate or applicable securities law. Now, on the valuation requirement that I touched on, there's an important exemption available for junior issuers. If a junior issuer, an issuer listed on a junior exchange, is subject to 61101, they generally don't need to go out and get a valuation, formal valuation. I'll touch on the fairness opinion piece briefly. In almost all cases, even when the take private doesn't involve a related party transaction, the board and or the special committee will obtain a fairness opinion in order to get an expertized opinion on value. The fairness opinion is not a formal valuation, but is delivered by an independent and qualified professional and speaks to the overall fairness of the transaction. Canadian securities law requires a fairness opinion in the context of a material conflict of interest transaction, that is, issuer bids, insider bids, business combinations, and related party transactions. With respect to the last question, Bennett, I don't think either a fairness opinion or a formal valuation is preferable to the other. Instead, they are each tools that the board and or special committee can or sometimes must implement in the context of a take-private transaction. A fairness opinion is customarily obtained even in the absence of a related party transaction for the board to get comfortable around value and to evidence the discharge of their fiduciary duties. A formal valuation is required in the context of certain related party transactions, but sometimes the board or special committee will obtain one to provide more fulsome disclosure to the shareholders as to how valuation was arrived at. Back to you, Bennett.
Thanks, Andreas. Very helpful. Riley, can you share some thoughts on the mandate for both the board and management on a going private transaction? Like, under what circumstances would the formation of an independent committee be required or desirable?
Yeah, absolutely, Bennett. So I guess as a baseline, I should say, whether we're talking about going private transactions or not, the general duty of directors is to act honestly and in good faith with a view to the best interests of the corporation. And this requirement that directors act in the best interest of the corporation means that when making decisions regarding the corporation, they must consider the interests of all affected stakeholders. And in addition, they also have a duty of care, meaning they must take reasonable care in reaching decisions on behalf of the corporation. So what this means in the context of a going private transaction is that the mandate of the directors is really to assess whether the proposed transaction is desirable or fair and in the best interest of the target company, taking into account the interest of all stakeholders. The mandate of the CEO, on the other hand, will typically be to continue as the company's prime public communicator throughout the process. And the CEO should take care to avoid discussing topics such as fairness and whether the CEO personally thinks the proposal is a good one or not, or what the board of the independent committee's position might be. The CFO and the other senior executives will usually be tasked with being the people required to collect all necessary information to help ascertain the value for the corporation. And in particular, the process will involve, giving technical presentations, financial presentations, reviewing forecasts and budgets, and collecting all the relevant information so that the financial advisors and evaluators can assess it, as well as attend and conduct oral due diligence sessions with management. The CFO and senior executives will also have to present to the independent committee and the board as a whole so that the directors can ultimately assess the prospects of the company in relation to the valuation. The CFO and all senior executives should likewise also be cautious to avoid expressing views on the desirability or fairness of the transaction, as that's really the mandate of the board and the independent committee. And then, regardless of the structure employed for a going private transaction, a committee of independent directors will likely be formed to supervise the process. And if needed, they will also select an independent financial advisor and supervise the preparation of any required valuation. We should take care to not elect any significant shareholder nominees or management representatives to the independent committee, and any material interests in the outcome of the transaction that will be applicable to other directors should also be carefully examined, as we don't want to necessarily taint the independent committee with any conflicts of interest. And then finally, the independent committee's mandate is typically to negotiate the price and terms of the transaction with the buyer, subject to board approval, and they will ultimately make the recommendation to the board as a whole as to which way they should advise shareholders to vote in respect of the going private transaction.
Thanks, Riley. So my next question is for the group here. So what are some of the key documents on a going private transaction?
Yeah, maybe if I could just jump in there again, Bennett, first off. Yeah. So the buyer and the independent committee will typically negotiate a confidentiality agreement as the first document. And this really allows them to facilitate the due diligence process and get deeper into their negotiations. Additionally, it's quite common for the buyer to negotiate a form of lockup or voting support agreement that the directors, officers, and major shareholders of the target will be asked to enter into. The definitive acquisition agreement is the key document that will be entered into between the buyer and target. And in most cases, a robust management information circular that contains prospectus level disclosure will also be prepared for the impending shareholders meeting or meetings, depending on if the buyer and the target each need to have one.
I'll jump on this one as well. So in addition to the key documents which Riley had highlighted, along with the circular, the depository will mail a letter of transmittal to all registered shareholders. So for anyone who's not familiar with the letter of transmittal, essentially it serves as a vehicle to collect acknowledgements and instructions from registered shareholders. Riley referred to the circular as robust. I'm not sure I would necessarily refer to the letter of transmittal as robust, but within the context of a corporate action, it's certainly a critical document, especially in a corporate actions world. So primarily, the letter transmittal serves as a vehicle to obtain written representations and warranties. One, to acknowledge that the shareholder presenting the shares has sufficient authority to deposit, sell, and transfer their shares to the purchaser. And then two, to acknowledge the purchaser will acquire title to those deposited shares in exchange for the cash consideration. And then secondarily, the letter transmittal is used to collect shareholder instructions, such as registration and delivery instructions for the cash payment. There may be sometimes a medallion guarantee for legal transfers that follows along with it if it's required. Lost certificate replacement requests. Hopefully this is not required. Payment method election. Shareholders may elect checks or wire payments. FX currency election. Nowadays on North American transactions, it's pretty standard to include a US dollar election if it's denominated in Canadian dollars. And then lastly, residency declarations. Again, common practice to include U.S. residency checkboxes, but once again, that's usually the tax counsel that will weigh in on that and advise if it's a requirement. Bennett?
Thanks. So, Andreas, in the event a shareholder doesn't like a deal, in addition to voting against it, can they dissent? And what does the dissent process look like?
Sure. Thanks, Bennett. Dissent procedures vary depending on the particular Canadian jurisdiction at issue. But generally speaking, shareholders can dissent in the context of a going private transaction. Typically, dissent procedures are only available for registered holders, and a notice in a prescribed form must be delivered prior to the issuer, prior to the shareholder meeting that was called to approve the transaction. Following the shareholder meeting, the issuer is responsible, generally speaking, again, depending on the jurisdiction, for delivering a notice of its intention to complete the transaction, which then allows the dissenting shareholder to perfect its dissent. Fair value of the target shares can be determined through either negotiations directly with the issuer or through a formal court process. That can be initiated either by the issuer or the dissenting shareholder. I would say that dissent proceedings are relatively few and far between in Canada. Although what we've seen is once a critical number of shareholders dissent with respect to a particular transaction, it can have significant implications on deal certainty. The obvious recent example that comes to mind is the Rio Tinto Turquoise Hill transaction, which involved dissents around 15% of the outstanding shares, leading to a number of meeting adjournments and changes to the deal structure generally. In the context of negotiating the definitive agreement, which Riley touched upon, the parties often negotiate a cap on the number of dissenting shareholders that as a condition to closing, just to preserve some deal certainty. That cap typically ranges between 5 to 10% of the target shares, but it is subject to negotiation. So we see some variability around that number.
Okay. Thanks, Andreas. So Jason and Chester, from the transfer agent's perspective, can you share some common steps you've seen made by the company or the advisors on going private transactions?
Sure. I've seen a lot of missteps over the years and always tried to avoid them. One common misstep is with the bridge meetings where the transfer agent is notified of the meeting too close to the record date. While there is time, while the 25 days between the meeting notice and record date. And record date, there's the 25-day period there, and that can be abridged. The transfer agent can't be notified on the record date because the transfer agent needs to send out searches and has to do certain setups. So there should be a minimum time prior to the record date where the transfer agent is notified. Another misstep is regarding the printing and mailing of the documents. So advisors, they should be aware of the size of the information circular in particular, and the amount of being printed. So the advisor should schedule enough time between the printing and the mailing date. So it's a lot different to mail 10,500 page booklets as opposed to 150-page booklets. So that needs to be thought of. Advisors and the company should be aware of dissenting shareholders. We have seen in the past where issuers are surprised of dissenting shareholders. And so it's always something just to be on the radar for. And an advisor should just have a general sense of mechanics of the transaction from the beginning in order to set the company's expectations on timing. And if the transaction is a cash for shares, which probably is since they're going private, it's important to have the wire be sent to the depository, that wire lined up. Sometimes closing, there's very specific timing on the closing. And we have seen where wires could be delayed for several hours, delaying the entire transaction. And then another misstep would be insiders that are not eligible to receive, let's say, cash or shares in a transaction, in this case, so private cash. So maybe somebody is with the company or insider just not eligible to receive the consideration. They would have to be put into registered form. So they can't hold their shares within CDS or DTC just because CDS and DTC, they'll expect to receive full funding. So if there is a shareholder within CDS or DTC not eligible to receive cash, they should withdraw their shares into a registered position prior to the effective date of the transaction.
I don't know if it's good or bad that Chester and I see all these missteps, but another misstep is the failure to plan ahead for equity awards. So the mechanics of how holders of options and PSUs and RSUs and DSUs are paid may be different from shareholders. That being said, mechanics for collecting elections and processing payments for equity awards should be discussed well in advance of mailing materials to shareholders. One thing to consider, if the equity award plan is administered in-house by the issuer and it contains a number of employees, the issuer may actually wish to run the payment consideration through their own payroll. This would give the option to their employees to defer taxes and also roll over into an RSP, which is quite common. On the other hand, though, if the equity award plan is administered externally by a third-party agent, the plan administrator will need to coordinate with the depository to implement a process to collect participant elections. And this is essentially accomplished by either a separate mailing or electronic communication to all the plan participants. Also has to be done well in advance of the closing. So in terms of the plan administrator depositing the plan shares, not sure if anyone's interested in this, but I find it pretty interesting. If it's a registered position, the plan administrator will submit a letter of transmittal to the depository with elections for the aggregate share position. So really just a single letter of transmittal. But if it's a beneficial position whereby the plan administrator holds the plan shares with a broker, then the plan administrator has to collect all the elections from the plan participants and submit their deposit instructions through their broker. So what's important to note here is if the plan shares are held with a broker, the plan administrator has to establish an early deadline, typically 3 business days or so prior to the closing, to allow them to gather all these instructions from their shareholders. And this early deadline is really designed to allow the plan administrator sufficient time to cut off the elections and then submit their instructions to their broker. And then once the broker gets those instructions, they in turn go online through the CDSX tendering platform and submit electronic deposit to their depository or to the depository.
Thanks, guys. That's a lot to unpack here. So my next question is for the group here. If you can provide top 3 recommendations to your clients that's contemplating to take the company private, what would that be?
Sure. So I'll start off. So on the transfer agent and bit of the depository side, when contemplating going private, be aware of the time frame it takes for a transaction to go effective, and to think about the potential hiccups from the onset in order to mitigate any potential issues, whether it be issues with planning an AGM, accounting for dissent groups, or any potential issues involving that are depository related. Thinking of these issues through well and ahead will certainly make the process of going private much smoother.
And another recommendation to ensure going private is become familiar with the demographic composition of your share register. It might not seem important, but it really is to do this up front, to contact the transfer agent and confirm if, for example, if CDS and Seed & Co. both hold the share position. If yes, that means the issuer likely has a significant U.S. institutional or retail presence. And this should be an automatic trigger to incorporate a U.S. dollar election into the circular, because shareholders outside of Canada will definitely not want to receive Canadian dollar currency payment. Some other things to be aware of with respect to currency payment: CDS can only accept Canadian and US dollars. So if there is a situation where there's elections for foreign currency, such as euros or GBP, CDS will actually instruct their brokers to withdraw their position from CDS and make a physical deposit. Also should be mindful that issuing Canadian dollar checks into a foreign country, for example, Australia, not really recommended. Not only is Australia fully dematerialized, but they're not really accustomed to dealing with checks. We have seen too many cases whereby there's clearance issues with non-local checks, and it could take up to 3 weeks to settle. Not to dwell on this point too much longer, but on deals where a CAD check is received by an Australian resident, it's actually returned from the Australian bank back to the Canadian bank for clearance. So that's why everything takes so long. So the cautionary tale here is really just suggest wire payments, first of all, but secondly, avoid issuing Canadian dollar checks abroad to the masses. It's only going to lead to clearance and settlement nightmares and IR escalations. What we would recommend here is to ensure that shareholders receive their preferred currency is first offer an FX currency election on the front end prior to closing, and then anyone who hadn't responded by default, those individuals would get currency by domicile for those non-electing shareholders. I have one more, if you don't mind. I'm going to go again. So a third and final key recommendation for an issuer considering going private is to weigh their options, have actually how they collect payment instructions from their shareholder. So in North America, we continue to rely on physical letters of transmittal, mainly because they're required to return physical certificates to satisfy a valid deposit. But over the years, with increased dematerialization over the last 10 years, the gradual phasing out of physical certificates, and then also the emergence of DRS, online portals actually have become more and more conducive for collecting shareholder payment instructions. Essentially, shareholders would just complete a digital letter of transmittal via a branded website. And that's become common practice nowadays as well.
Great. Yeah, I think those are great tips. I completely agree with what Jason and Chester have just said. To add to that, I would also recommend that a target company give due consideration to who is going to be on their independent committee early in the process. The independent committee plays a vital role in these transactions, and directors with the experience and ability to participate in the process fully is really imperative. Secondly, I would recommend that early in the process, obviously the target should sit down with their legal counsel and review securities laws to determine whether or not a formal valuation is going to be required and what type of transaction this might be considered under Multilateral Instrument 61-101. And even if a formal valuation is not required, whether it might be wise to obtain one anyways. And finally, though, as we mentioned, they're not legally required. It is common practice in the context of a going private transaction for the board or the independent committee to obtain a fairness opinion to support their judgment and to evidence that they've discharged their fiduciary duties. And this fairness opinion is typically obtained from the same financial advisors that would be providing any required formal valuation.
Thanks, guys. Now, I have some follow-up questions based on your earlier comments. Jason, I guess I'll start with you. You mentioned earlier that web portals are becoming more conducive for collecting shareholder payment instructions. Can you briefly describe how this works? Like, how does a shareholder access the web portal, and what can shareholders accomplish within that portal?
Okay, so that's a good question. Look, here's the deal. So Joe Biden always says that. I love that line. I had to fit it in somewhere, so hopefully everyone's okay with that. There are a couple of ways for shareholders to get access to a web portal. The first method is via mail. So shareholders are mailed their login credentials, consisting of a cover letter, and in that cover letter, they would describe the transaction, and along with that would include their login instructions to the web portal. The second method, it's more convenient, is via email, but it all depends if the company actually has email addresses for its shareholders. And if they do, in this case, the shareholder would receive firstly an invitation email, which would include specifically their unique login or account code. And then it would be followed up by a secondary email, which would include their secure passcode or control code is what we like to call it. With respect to what the navigation experience is like for the shareholder. So once they get their two codes and log onto the site and gain access to the event branded portal, they have the capability to do a multitude of things. So they'll essentially land on a web page where they can click, view, and acknowledge terms and conditions of not only the website but also the go private transaction itself. They can confirm registration and address details, make a currency election. They can provide tax certification. There's capability nowadays for online Form W-9 and Form W-8 Ben completion right via the web. Provide wire payment instructions, as I alluded to earlier. They would just complete their banking details via the essentially electronic form of letter transmittal. Obviously, there's options for checks if they wish, but nowadays individuals typically like to receive wires, especially if the proceeds are significant amounts. Functionality for electronic signature. And once they pass all these prompts, the shareholder essentially submits their instructions via the system and then get a generated email confirmation. High level, that's pretty much how it works.
Okay, great. Thanks, Jason. And Chester, can you expand further on your experience with the level of shareholder engagement on the transfer agent side and the depository side regarding private transactions?
Sure. So while you would think that all shareholders are really keen to vote and to submit their letter transmittals, that's quite often not the case. A lot of people just aren't paying attention. So typically for going private transaction, there would be a special resolution in a special meeting, which typically has a little bit more shareholder participation than a normal AGM. But Computershare has seen a wide range of proxy participation from as low to 10% to as high as 80+%. So it's important for the company to engage its shareholders to try to obtain the highest amount of votes possible. For the depository side, as I mentioned before, CDS and DTC, and all the beneficial shareholders behind CDS and DTC that hold shares with brokers, they're all going to get paid shortly after the effective date, basically on the payable date, 3 business days after the effective date. But registered shareholders, typically the depository will only see about 20% or less of registered shareholders submit their letter of transmittals to the depository prior to the effective date. And so it's important for the issuer to engage those shareholders if possible, and to encourage them to submit their shares and their letter of transmittals close to the effective date or shortly after, just merely for the facts that they could be paid as quickly as possible.
Two things to add there, Chester. I echo the shareholder engagement comment that we see a wide variety of participation levels at shareholder meetings that are not contested in nature. And for that reason, we often get a handle on what the quorum requirements are for the particular issuer in advance of the meeting, because where shareholder participation is low or expected to be low, that can sometimes be a problem, and we want to make sure that we have a good handle on that, before we mail materials. And one of the ways we deal with that, of course, is through encouraging the issuer to retain a proxy solicitation agent in an effort to increase shareholder participation, especially in the context where the transaction itself isn't getting the same amount of enthusiasm in the market, which could potentially lead to a challenge around votes, or where the issuer has historically had low levels of shareholder participation, and we want to make sure, either from a disclosure perspective or simply to ensure the vote is properly passed, we want to make sure that there are sufficient amounts of shareholders participating in the meeting and approving the transaction generally.
Great, thanks, guys. Andreas, going back to you. So what are some of the key differences between a supported or friendly go private transaction versus a hostile go private transaction?
For sure. So very simply, a support transaction is one that is supported by the board of directors of the target and recommended to its shareholders. A hostile transaction is one that does not have the support of the target board, put very simply. On its face, hostile transactions or unsolicited transactions are not very attractive for the buyer. Hostile bidders do not generally have access to due diligence materials. That could lead to issues around price discovery and understanding the true value of the target that they're seeking to acquire. Hostile takeover bids also are fairly costly, and they're subject to defense mechanisms that might be imposed by the target board to preserve flexibility. So, for example, poison pills, which isn't as common in Canada, but occasionally do get implemented. And then second, of course, is just defensive private placements. Generally speaking, hostile bidders end up paying a slightly higher premium to shareholders to overcome some of those defensive techniques that I touched on. Compare that to a friendly transaction, which provides for greater flexibility around structuring and provides for a greater level of deal certainty, given the expectations, as Riley had mentioned, around lockup agreements, support agreements, as well as obligations that are negotiated and imposed on the target board to recommend the transaction to its shareholders. The vast majority of go privates are structured as friendly, but occasionally we do see unsolicited transactions take place for a variety of reasons, including leveraging past or taking a second step after a friendly transaction has, for whatever reason, deteriorated, or using a hostile or unsolicited bid as a way to negotiate directly with the shareholders. So that's what I would say, Bennett.
Thanks, Andreas. I have one more question on my list before we go to the Q&A session with the audience. Riley, you mentioned that it wasn't a legal requirement to obtain a fairness opinion in a go private transaction, but that it was generally common practice. So why would a public company want to consider obtaining a fairness opinion and pay for it if it's not legally required?
Yeah, thanks, Bennett. You're entirely correct. As we've mentioned, in certain situations, the formal evaluation will be required, but it's not always illegal, or it's not a legal requirement to obtain a fairness opinion. However, it's very common for boards and or the independent committees to obtain these types of opinions, as it's very good evidence that they've exercised their fiduciary duties. These opinions are typically cited in the target's disclosure, such as the information circular that's sent out when we're seeking shareholder approval for a proposed transaction. The opinion is usually in written form and generally concludes that a specific transaction's terms are fair to the target's shareholders from a financial point of view. And so while they're not required, a fairness opinion can give the board additional comfort that it's satisfied its duties when it recommends a transaction for approval to its shareholders. Now, fairness opinions are always tailored to the specific situation. So when you've got arrangements or other transactions that are likely to be opposed by certain shareholders, in particular where you have some transactions where there are significant conflicting interests, boards and their advisors would be wise to obtain a fairness opinion and ensure that this opinion discloses enough analysis so that security holders are meaningfully informed of the terms of the transaction.
Okay, thanks, Riley. Now, let's take a look at the questions that we got from our audience here. I'm just going to post them to the group chronologically. So first question is, are there any more life sciences companies being taken private? Now, if I may jump in for 1 second here, I personally have not seen that, at least in Canada, more in the US. Most of these life sciences companies in Canada, they're from my observation, they're in the growth stage, early stage, so they're not in the public market yet. But love to hear what you guys think in terms of the trend here for life sciences.
Yeah, I would echo that comment, Bennett. Just in my practice, I haven't seen that happen yet. I think there will be quite a bit of movement in that space in the coming years from what we've seen recently, but to date, that hasn't made its way north of the border yet.
Yeah, on the depository side, I could say that we do see a variety of corporate action events with life science companies, but I can't recall offhand as to just going private transactions.
Okay, thanks, guys. Next question, would a director having a stake in the stock of the company, non-controlling stake, have a conflict of interest and would not be able to be on the independent committee as an independent director? I think that's a question more for Riley Andreas.
Yeah, you want to take the first one, Andreas? I can jump in.
Sure, I can take a stab. I think it's a contextual analysis in terms of what constitutes a conflict of interest for the purposes of being able to serve on an independent committee. The ownership of stock alone generally wouldn't be enough to discount the independence of a particular director. But again, it really comes down to the context and whether this particular director would have the ability to significantly influence the issuer in that case. So I'd leave it at there. I mean, it's ultimately a determination that the board needs to make and get comfortable with, of course, the input of advisors as to whether a conflict exists and B, whether they would be eligible to serve as an independent member of a committee to assess a particular transaction. And it's one that has some prescribed there's some particular rules about it, but it's also contextual and sometimes hard to give advice without understanding the full nature of the details.
Yeah, I would echo that. There are a few bright line instances that will automatically make a director not independent anymore, but ultimately it's up to the board as a whole to decide who is independent and who isn't. Just the ownership of stock alone and non-controlling position would not automatically disqualify them from the independent committee. Now there are, as Andre said, it is contextual. There are other what we call collateral benefits sometimes bestowed upon directors if they're getting a change of control payment under their employment agreement, or maybe they have options that other stockholders aren't holding that are triggered on a change of control, or they're getting a nice bump in salary to stick around after, then some certain things like that will disqualify directors or management from that independent committee. But it is a highly contextual question that we have to look at each time.
Okay. Thanks, guys. The next question is, what is the success record of the companies taken private? Maybe I'll defer this one to Jason and Chester. You guys at Computershare have a front row seat at many of these go private transactions. So can you share your thoughts on what you've seen in terms of success rate generally?
Well, I don't think we've really seen. Go ahead, Chester. Go ahead.
Sure. In terms of success rate, as for the, let's say, the meeting, typically we don't see too many. Typically, they pass. It'd be pretty rare for one of these transactions not to pass at a meeting. So that's what I'll say there. I can't recall one maybe several years ago, but in most cases they go through.
Yeah, I was going to say the same thing. We may see some dissident shareholders, but I think that's common with any going private transaction where there's some shareholders are just not on side or they have some different views. But those situations are very rare. So yeah, the overall transaction itself usually goes public, and they're a success. So much so that you'll see the many cases where they'll end up going public again and possibly go through the same process years down the road.
Yeah. Riley and Andreas, have you guys seen any go private transactions being voted down?
No, honestly, in my experience, I've never been a part of a go private transaction that wasn't successful. There are some that don't proceed to the meeting stage, and very early on they fall apart for due diligence reasons or something like that. But once you've mailed out the meeting materials and you're booking court dates, if you're doing a plan of arrangement, it's quite rare to see a deal not close.
I'm in the same boat. Although oftentimes, as you're leading up to the meeting, you're tracking shareholder participation, and things don't necessarily look very good. And that's where the proxy advisors, in particular, really do a great job at getting out the vote, especially a few days prior to the cutoff. So I have certainly been involved in a few close calls that were fairly contentious, but in each case, the issuer, the target issuer, ultimately was successful at the shareholder meeting.
Okay, thanks, gentlemen. Those are all the questions we have from the audience. So that was fantastic. So before we sign out, I'd like to thank Jason, Chester, Riley, and Andreas for the insights, and everyone on the line for joining us today. I hope you all find the discussions to be useful and give you some new ideas for your business. And please reach out to us and Computershare with any questions or comments. That's it for this webinar. Enjoy the rest of your day. Thank you.
Yeah. Thank you, everyone.
Thank you. Have a good day.